Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to explain to you what it means when the judge sends you out for a post-hearing consultative evaluation. And basically a consultative evaluation is when Social Security sends you to a doctor on one of their panels, and these are typically doctors that do this to make a little bit extra money. Sometimes it's a retired doctor, but there are certain doctors on Social Security's local panel that they will send you out to. These are not employed by Social Security, but they do work sort of as a contract basis for Social Security. And generally it's going to be either a physical medicine doctor, an internist, a general practitioner. It could be a psychologist or a psychiatrist, or it could be a specialist. So for example, if you've got a problem with irritable bowel, the judge may send you to a gastroenterologist. If you've got some sort of specific mental health problem, the judge may send you to a neuropsychologist. So again, depends on the particular situation, but the judge may send you out. And it's not necessarily a good thing or a bad thing if a judge does this. What typically will happen is the judge will see some inconsistency between your testimony and what's in the record. For example, I had a hearing recently where my client was clearly very, very anxious and depressed. She was crying throughout the hearing. Her medical doctor, her internist, described a great high degree of depression, but the Social Security consultative evaluation that had already been done talked about a mild level of depression. Well, that was not consistent with her treatment or with what the other doctor said, but the treating doctor was not a psychologist, he was an internist. So the judge was basically feeling like we need to have more information as to why the client's or the claimant's presentation was at such a severe level, and the internist had such a severe level noted in his records, but the treating the consultative psychologist didn't have that. So she's going to send my client out for a consultative psychological evaluation. So that's just a way to rectify inconsistencies in the record. I think judges are very, very concerned about consistency in their decisions, that they don't want to see medical records that are inconsistent with what they write in their decision. So they're looking for medical records to support what they're going to come up with. And of course, sometimes the judge will send you out because there's not enough medical record there. And you talk about something in the hearing and the judge tends to believe you, but the judge cannot approve you based on your testimony. There needs to be some form of medical support. So for example, if you talk about a severe back problem, but that had not really been developed very much in the record, and maybe because you couldn't afford to go to the doctor, the judge may send you out to an orthopedist for an evaluation of your back. So again, it's not necessarily a bad thing or a good thing. It's just a way for a judge to develop the record. That one of the things judges have to do is to fully develop the record so that the decision is based on medical science, not based purely on your testimony or the judge's hunch. If the judge does send you out for a consultative evaluation, you'll get a letter in the mail probably 2 or 3 weeks after the hearing, maybe even less than that, giving you the date and directions and the name of a doctor. You need to definitely want to go to that. What happens after that is once the record comes back, the medical report comes back, your attorney, I'll get a copy of that. I'll have a chance to write a little follow-up brief or follow-up argument, or sometimes I just say I have no opposition to introducing this into record, but I typically will do something just to confirm up my theory of my case, and then the judge will issue a decision. So yes, it does add sometimes 2 or 3 months to the process, but it gives the judge a more complete medical record, and you need to cooperate with that doctor or that consultative doctor in any way, shape, or form you can, so that the judge will see that you've been cooperative and that it will expedite the processing of your decision. So that's what a post-hearing consultative evaluation is. Again, it can be both for mental health or a physical medicine problem. You need to go to it, and your attorney will have a chance to review the report and make comments and get that to the judge, and the judge will use that to make his or her decision. So I hope you found this helpful. If you did, please give it a thumbs up on YouTube or Facebook. Subscribe to our channels. Let me know if you have any questions. And until next time, this is Jonathan Ginsberg wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know, how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.